Yes.
National Lordship. On matter on anticipatory bill was filed before the High Court Kolkata. On 22nd August 2025, order have been passed by the minister. It was transferred to the school for regular surgery, but not listed. The anticipatory praying it may be listed on Monday and matter may be.
On Monday.
I am giving the reference first. The order has just passed.
This is Manoj Paul.
Manoj Paul.
Do I need to record any formal order or it can be listed on Monday?
Migration to listed on Monday.
All right. In terms of the order passed by the principal bench. In terms of the order passed by the principal bench in CRM A 6 of 2025, let this matter be listed on Monday. You are there in this matter?
No. Online.
This is wondering whether the records would have come.
Records have come.
Usually an order is passed there or say place it. But usually the court passes an order directing the registry to immediately transmit the records by special messenger. Petitioner has to wait for the special messenger, then it comes. Otherwise, the file must be lying somewhere in there.
I think there is a direction to forthwith. There's a direction to transfer.
Then in that case, it must be on its way or reached.
We'll see if it's on Monday not there, then we'll give a date. Or shall we keep it on Tuesday? Maybe it will come on Monday. Keep it on Tuesday. All right. We'll see if the record has come or not. And just follow up with the record.
Online.
I want
Yes.
Yesterday, my lord directed me to issue notice upon the one higher issue notice for them.
Who's appearing?
Matter was appeared before the terms of 7 January 2025.
Yes.
And direction was given to the respondent to file their opposition. But till date, this matter has not been listed.
Who's appearing for the administration?
Rakesh Kumar and private respondent.
Let this matter be listed. Dal this list में डाल दो to be included in the list for Tuesday.
The three also kindly to mention yesterday. I had
Yes.
With regards to the so first of all, I want to kindly have the appellate side rules. I've just flagged the relevant one. So it's chapter 5, rule 9, with regard to the general rules of procedure. In the
Chapter
case of the pink flag is what.
in the case of an application for revision, application shall be accompanied by a certified copy.
Chapter 4 deals with the rules for applications and affidavits. Chapter 5 are the general rules, and we have a separate chapter which is 11 for criminal business. But the specific provision is rule 9 under chapter 5.
So in case of an application for revision, the application shall be accompanied by certified copies of each of the following documents, right?
We are on 1.
The judgment decree,
order to which the application relates.
yes,
So since I'm challenging an order passed by the learned CJM under 175(3),
yes,
that order certified copy must accompany my app.
yes.
This is the rule. Now, so far as the application is concerned, we have taken out the application for the certified copy. I am informed, I've taken information today as well. We are instructed that for some reason I do not understand, the original 156(3) application filed in the court records has been transmitted to the police station. I could have
Okay.
understood if a copy has gone, but we are instructed that there are only copies here in the file. The main original 156(3) application has gone to the police station. The order as well has been sent to the police station. The FIR, because the order says that compliance to be filed on the 3rd of November, the FIR has been lodged, but that copy also has not come. So everything will come back here on 3rd of November, which is the next date fixed before the lottery court. So effectively, my application for certified copy cannot be processed. Now, this is what the High Court has said on 2 occasions. My Lord will first see. This is in 1980. So this is reported at AIR 1981, Calcutta 365. Paragraphs 1 and 2 deal with the factual matrix, but you'll also will see the submissions by the Royal Senior Counsel as it then was paragraph 6. More specifically, the last 4 lines of paragraph 6. And the observation of the court, which is most relevant, is at paragraph 10.
Paragraph,
Paragraph 10. These are the observations of the court. Now, here I must point out what the court is referring to here is a civil matter, order 41, and at the same time, because it was an original side matter, the court is referring to Rule 2 of Chapter 31 of the original side rules, which don't apply in Port Blair because we are outside the original side geographical jurisdiction. So this judgment, Anadi, dealt specifically with granting of leave in such situations in light of the original side rules. Now we are technically on the appellate side, and for that matter, will kindly see 1997. Paragraphs 3 and 4 are the factual matrix, but I would beseech your lordship's kind attention to be drawn to paragraph 15 first. 14 and 15 refer back to the 1981 judgment in Nadi. And at paragraph 20, 21, and 22, it is discussed how on the appellate side, we do not have any provision of this nature, but for the benefit of litigants and in the case of urgency in the interest of justice, there is a procedure existing by which this court may grant me leave. The requirement of filing the certified copy cannot be dispensed with. Provided I give an undertaking that I have applied for it, it has not been made available to me, and as soon as the copy is made available, I will file it in the registry. On the strength of that, my filing and listing can be permitted. I may move it urgently.
this is also civil matter.
Yes, ma'am. This is also a civil matter. The difficulty is we have always taken leave.
You show me any judgment where leave has been granted in a criminal matter where
With the greatest of respect, we always take leave on a practical sense. It is granted because of these judgments which have permitted filing without certified copies. And in fact, the logic here, my lord, if your lordship allows me, I can extend it further. If my lord sees the old CRPC and the new BNSS, the provisions of law never required a certified copy. In fact, your lordship is aware, every convict in an appellate proceeding, for example, is provided a free copy of the judgment.
That's all right, Mr. Kabir, but the difficulty is if I pass an order like this, then these becomes precedents.
No, madam, that is precisely why no orders are ever passed. What is done is, in view of the urgency of the situation, based on the fact that there is an accepted practice on the appellate side of the court, allowing this, your lordship's officers usually give a note to the registry, which accepts the filing and listing. Thereafter, I have to go to the registry and give an undertaking to file the certified copy as soon as I get it. And on that basis, the matter is listed and taken up again. Because technically, without the certified copy, it's defective. It cannot be listed or.
But is the practice followed here?
Yes, sir.
It has been done in the past.
But I have done it personally in Calcutta. Here I have done it on 2 occasions. But in both those occasions, we have, as soon as we get the certified copy, we come in. Because effectively what it means otherwise in this given situation, because the next date is fixed in November, it means that till November, I cannot move any application before the order. And the order is passed on 6th of August.
Any such order which you have, the directions were given to the registry?
No, madam, but your lordship's officers will be able to apprise the court that we do take leave in this fashion. Leave is granted and sent to the registry by way of orders will never be passed because
Not orders as such, but direction must have been given by the court.
no, court just says permit. For example, there is a rule that we cannot move with, before 24 hours has expired.
Just permitting on a verbal instruction to the registry.
And that is the practice. Your lordships would say that leave is granted, give it. They would send the written note, the registry permits. Even I'm giving your lordship a simple example.
ये
48
होता
hours
है,
has
ये
been elapsed.
ये होता है हाँ unlisted move होता है and they will give the certified copy when and take an undertaking and it can be listed. Then you list it with the undertaking. Ask the registry to do it. आज के लिए keep it Monday or Tuesday कर that is done
Your lordship's convenience.
Tuesday.
I don't really see in Calcutta in the principal bench, this is a regular thing in urgent matters. Because the rules say we have to file it, wait for 24 hours. It can be listed only after expiry of 24 hours. Before that, an affidavit cannot be read in the court. Even in those situations, it's very urgent.
No, I'm just thinking that no, on the mentioning there should be a direction passed by this court that since the petitioner had already filed for a certain.
On what file would your lordship pass through?
That's the problem.
Because the file is not numbered. So we don't have that system where there's one diary number in the
Diary
second day. So then if your lordship is to pass an order,
There has to be a.
there has to be a file.
Let's follow this practice only, which is there.
No, but that's why I have apprised your lordship of the legal.
It's important to understand that, because even the rule which you have showed me, on which I had passed that modification order. Now, even a contempt, can the same rule be applicable?
Now I tell your lordship a very big defect. There are unfortunately various things which people in the administration do not appreciate fully. This is the old one. I don't know if your lordship has seen it. I'm sorry for the condition of the. We'll see this middle one. And this was issued back in 2010. We followed it since then. Now, in the meanwhile, the Honorable the Chief Justice, couple of years back, had decided that there will be a separate bench set up. Now, the word unavailable here has to be read in context of the Port Blair rules. The Port Blair rules have been amended. Madam, will get that also. It's in the book. I can show that. 4B has been amended to say that when the circuit is not sitting and is not in session, the principal bench, the designated bench will have the necessary authorities. The old 4B said You have to go and take leave of the Honorable the Chief Justice, who will then assign the matter to someone. That changed. Now, what this means is the bench will never be available until the next circuit rolls around. And wherever his lordship is now sitting, he cannot have jurisdiction because of the operation of the 4 circuit rules. That as long as the circuit is here, that bench has no.
But then in that modification which I have passed an order, looking at the rule condition, I was convinced that I can. But if the contempt has to go before the same bench which has passed the order, the same principle should apply even to the modification.
In modification, this is never found. And I can show you lots of orders for modifications.
Modifications can.
I can show you
And
lots of
contempt that has to go before the bench which has passed the order.
contempt and review.
And review.
But now, after 2010, there's been another change, which is a funny change because it says that it will go before that bench. If both judges are not available, then this says it has to revert to that determination.
Correct.
Now there's a new thing, which says that you will go to a designated bench. So if your lordship sees in the original side,
Yes, there is a designated.
there's a separate bench designated to hear matters which
Yes,
belong to no court.
Yes. Yes.
So that contradicts this. So that's why these have not been harmonized, but in terms of practical.
Because I've seen in the roster, one particular judge has been assigned that roster.
Exactly.
Yes.
Now, there's another very difficult question to answer. If that is a position so far as the appellate side is concerned, the appellate side does not extend here. So whether that determination would apply here. If that is the case, don't take me amiss. How is a division bench hearing PI? So there are these things around which we work around with, we find solutions as we go along.
Yes. Technically, no. We can't. Technically.
There has to be a workability to ensure that the litigant has access to a.
Exactly.
So that is a work. Modification, I can show you much of any number of orders I have moved here myself. The modifications are.
I believed you and I passed it out.
No, without that assurance, I would not have said something so bold. A second mentioning it, your lordship permits. Yesterday, your lordship was pleased that that electricity happened, Mr. Mishra is there.
Tuesday, we have
Yeah.
kept.
So written arguments, my lord, I have made just a short sort of bullet points, whether your lordship would like me to.
No,
enlarge.
bullet points.
This is a chronological evolution of whatever has been.
I'll keep this, but give me a.
More people. Nice. I'm giving a copy to my learner.
Which will help me in deciding the.
I have understood.
I'll just keep it for my personal. ये जो फाइल मैं घर ले गया हूँ ना, उसमें डाला.
That will be a 305.
Yes, call out the list. Yes,
My lords, right, that's solution. I appeal for the petitioner.
yes,
Responded, lords.
Patent application is for seeking of anticipatory bail.
yes, sir.
Apparently, copy the prosecution process of some the private service. I pray that it may fix for corpus CD or.
Lordship, CD may be called, maybe fixed on Wednesday or Tuesday, any convenient hours.
We kindly fix on Monday.
Petitioner has, straight down, petitioner has filed the present application seeking anticipatory bail. Full stop. Let the case diary be called for on Wednesday.
Along with
Let
CD,
the-
extra we also recorded.
Let learned counsel for the respondent seeks and is granted time to bring the case record. Let this matter be listed on Wednesday.
Wednesday.
Wednesday. Wednesday.
Let it be fixed on electricity.
Wednesday. Wednesday, not today, Wednesday. Mr. Mishra, we'll have a solution to all these problems.
Tomorrow I am going to the office of presenting Indian.
Let's solve it.
In this matter, senior conference is now hearing for contempt and election. The contempt order was passed by Justice Dipankar Mehta, was got retired.
Lordship, I generally used to appear on behalf of the electricity department. He-
So again, where Mr. Deep? Mr. Kabir was here.
No, Mr. Kabir is not up.
No, I'm saying this is again contempt. So contempt, what will happen to this? This
So
has
the order was passed.
by Justice Datta. Now he is no longer there.
Lordship can take up.
This court will hear them.
I request my learned sister to serve me a copy to the contempt of the hearing.
You have not given a copy of the contempt.
Yes.
Actually, earlier.
Give a copy.
somebody else Was appearing, so I am requesting that.
I said.
Give a copy. When do you want?
Let it be on Wednesday. Lordship.
Not today, Wednesday.
So like,
This must be order passed for granting of an electricity connection.
if you have not gone through the file.
What is the issue?
You are right.
Wednesday, not today.
Okay.
So like.
Correspondent by Lordship, granted Mr. Order by his Lordship, order by Justice Lordship.
Yes, sir.
Evidence available. It will place before the. This will be directed to the place.
Learned counsel for the petitioner has filed a contempt petition alleging that the order dated July 9, 2025 has not been complied with. That's the order, right?
Yeah.
July 9, 2025 has not been complied with. Let this matter be listed before the requisite appropriate bench, subject to orders of the Honorable Chief Justice. यही order होता होगा यहाँ पर.
Yes, my lordship, we are representing the petitioner. There is a change of date, my lordship. Only yesterday we have been requested to appear, but no file has been handed over, not handed over first. My trade, let it be accepted, my lordship.
Learned counsel for the takedown. Learned counsel for the petitioner states that it's a changed brief and he seeks time to construct the file. Full stop. He further prays for this matter to be listed before the next available circuit bench. Full stop. Let this matter be listed before the next available circuit.
Lordship, I was appearing along with Mr. Sabir in the respondent union, Lordship.
Just take his appearance. What is your name?
Manish Gothakura. Lordship, I will giving the chat box.
Alright. The senior's name will not appear. Who's not appearing? Just give your appearance.
And just provide.
Next.
Item 6 is an appeal against acquittal. I am appearing for the accused. However, this matter has done 3 rounds. I have been acquitted twice. The allegation is 354A1. Sexual harassment at the workplace. This person is supposed to have said the lyrics of a Hindi film song, which are offensive. He was initially convicted by the magistrate, moving on to the Sessions Court. Sessions Court acquitted him. That order was challenged by the complainant in the High Court. High Court sent it back to the Sessions Court. Sessions Court heard the appeal again, acquitted him a second time. Now that has been challenged here. Now, in view of the fact that there is technically no criminal case pending, because he's been acquitted. The pendency of this appeal was one where at one point of time, both parties were probably in a position where they would sit and work. So the matter was referred for mediation. Now thereafter, my lord, we've heard nothing from anyone. This court has said repeatedly, let the file go to the registry, let the registry take it up in the mediation proceedings. If they can sort out when and go. From the registry, we have received no word. Whether the file has even gone to the registry, we are on.
Now, last order is No mediation report has been received. In such circumstances, let the matter be brought into the notice of the learned registrar for compliance of.
Same situation. Now, the difficulty is that light of 362 CRPC, once the court has opined that the matter has to go for mediation, till such time as we get a report that the mediation has failed, the court can't proceed because that order can't be reviewed.
We'll have it on Wednesday. Yeah. एक बार रेफरेंस आपको दिखाओ क्या करते हैं. No, Wednesday, not today. Has this order been communicated to the registrar?
Here it's put on. It's still gone.
You know, wherever we stay, we never see the sites.
I'll take up. I'll take some.
Just inform him.
It may just be that the registrar is not on it.
Exactly, that's what I think. I've asked him also, but
I'll see today. But just on a slightly different note, I just received some unsettling news from Calcutta. So that's still just possible.
he appeared before my court recently.
I was supposed to meet him on Monday again.
Very sad.
The criminal bar has just informed.
Sad.
Civil matter, I appear for the accused persons who have been discharged from the case.
This matter, Rajpal Mohan appears for petition. I wait for next year.
You appear for the
Accused.
accused.
The CBI.
CBI, Miss,
CBI has come to
this take down at the request of the state bracket CBI. Let this matter be listed before the next available second bench.
For the respondent, it's out of station, I don't think. I'm paying to fix it in the next statement.
Next thing.
8 and 9 also.
I appear of the petitioner.
8 and 9, keep
Both for me.
8 and 9 both, right?
Yes.
Not today.
Okay.
We'll keep it on. When do you want?
Wednesday means.
Wednesday.
Problem.
apply.
That's bad for the official respondent also.
Who appears for the petitioner? Mr. Jaipal is for the petitioner. Where's Mr. Jaipal? He was there in the morning.
The pleadings are all here, completed.
Then let's hear it. So let's finish it. Where's Mr. Jaipal? Who's up? Any junior folk, Mr. Jaipal? Not today, Monday. Monday. available circuit bench.
Apply.
20, 90, all.
Yes. Yes. Learned counsel for the petitioner seeks time to file reply to the affidavit in opposition. Seeks and is granted. How much time? Seeks and is granted 1 week time to file her reply to the affidavit in opposition. List before the next available circuit bench.
21, several possibilities. I for the respondent.
Twenty-one.
I'm for the respondent.
Who's for the petitioner? Miss- Somebody just appeared for Mohammed Tabriz, the junior. Pleadings are complete?
Not sitting there.
Not today. Not today. Monday. Yes, Ms. Das. Yes.
Petition.
Down to 54, 134.
I'm waiting for next circuit, and response. It's pending.
At the request of the learned counsel for the petitioner, the counsel is in some personal difficulty. Let this matter be listed before the next available circuit bench.
So 23, number 301, I have 24, number 314, 23, 24 is connected, matter not last 5 years.
Who appears for the petitioner? Not today. What is the matter about?
Sir, you know, we are seeking for an age relaxation. They are the Anganwadi workers. So in terms of the government scheme, they describe what are the qualification, what is the age. They say that, sir, they are working long period of time, this is not the age relaxation. They are not come under the particular scheme, because notified by.
We'll hear it, we can dispose it off.
Three days, sir.
We'll have it Monday. Monday.
Twenty-five, 4, 8, 5.
File affidavit in declare, just 2 days time is.
25, 26.
2 days time is.
Learned, you're for the, learned, you're the
I
respondent.
am for.
Affidavit in reply to the affidavit in opposition.
Yes.
Learned counsel for the petitioner seeks and is granted 1 week time to file his reply to the affidavit in opposition. Let this matter be listed before the next available circuit bench, 25, 26.
Twenty-seven, I'm just 5 days of twenty.
इसमें वो I think last time also ये जो last one है ना is granted further time. Last time also you had sought time. No, I'm asking him. Yes.
Yes.
Last time also you sought
Yes,
time.
my client was out of session now.
Further time. Huh? Seeks and is granted. Seeks further time and is granted further time.
Okay.
Yeah, what is this? Next circuit. You're for the petitioner.
I'm for the rest.
Why you don't want to do it in this circuit? Then the matter, it's a short matter. What is the issue? All right. Learned counsel for the petitioner states that she is in some personal difficulty and prays for this matter to be listed before the next available circuit bench. Full stop, let this matter be listed before the next available circuit. Yes. This item number?
28.
What are you seeking? Retrospective promotion. Yes, Mr. Rakesh Kumar.
Your lordship, let the matter be fixed on Tuesday, your lordship.
Not today, Tuesday. Tuesday. Any matter where both the sides are there? Mr. Jaipal, there were certain matters you have taken time.
Point number.
Any matter where both the parties are there and they want to do the matter. We'll have it Monday, the matter will come. Rest item, give item 39.
38.
Give item 38. Not today. Any matter where both the parties are there?
One matter is answer my reverse side is not there. That's
He has taken. Oh, virtually, I will not hear a single matter because the voice is absolutely not clear, madam. Sorry.
Your Lordship, in item 34, Your Lordship, there was a direction to file.
First, improve your connection, then we can hear you.
I'm sorry, Your Lordship.
Which is that matter? 38. 38. Madam, help him.
Also, there one claim by the Eastern witness, I of just supplementary policy certificate. So maybe Eastern witness, because supplementary list already.
Witness.
So I just informed this honorable court.
I was not aware. Yes, what are you asking?
Lordship.
Yes. And who's supposed to file the affidavit in opposition?
We have to file by lordship, we are sick. I paid some time they need.
All right. Learned counsel for the respondent seeks and is granted further 1 week, 2 week.
2 week minimum.
Further 2 weeks time to file his affidavit in opposition. Full stop. Reply if any to the same within 1 week thereafter. Full stop. Interim order granted earlier is extended by 8 weeks. 8 weeks will cover it. 8 weeks or until further order. Full stop. List before the next available circuit bench.
Okay.
No, item 39, my, the same.
39, okay. Call for 39.
Order dated 8 July 2025. Now a special officer was appointed to hold inspection of the property industry. To ascertain certain terms of reference which this court has formulated. So this order was challenged before the Honorable Division Bench. The Division Bench have dismissed my appeal and granted liberty to the special officer to fix another date. So by order dated 8 July 2025, the interim order was made of for a period of 6 weeks. The special officer has to undertake her job, but since no notice has been received, now the interim order needs to be extended.
Yes, Ms. Babita.
Because still the inspection has not been started. We have not received any notice from the side of the commission.
Affidavit in opposition has already been filed, right?
Appointment number.
I have not made an application, but I argue not to this court. No more to exercise because the order eviction which I have challenged here
Yes.
indicate that I am an encroacher, I am my own property. Tahsildar says that along with my property, I have encroached another government land.
Last order, there's no stay.
8th July 2025 order may kindly be seen. 8th July. The last July. 8th July. Was extended for a period of 6 weeks.
Where is Miss Shipra Mandal? Is she here? Hmm?
That's it, I'm calling. That's it.
We'll have it on Monday.
Yes, sir.
Yes, Miss Mandal, have you conducted the inspection here?
So they went to the appeal also and.
Appeal against what?
Against this order, appointing special officer.
Oh, you challenge this order
I have
now?
lost it, boss. I have lost.
But.
So, have you paid her?
Lordship, that's not a big issue, Lordship. Amount was fixed. I can do it today. Here and now I can do it. That's not a big issue, Lordship.
You go and conduct the inspection.
That went to the spot and they informed me that appeal is pending. So.
Then obviously, how could she do it?
So the division bench have extended the time to hold inspection.
What is the next, what is the date of the division? What is the date extended?
Everything was given to her. She has to fix a date. She has to send a notice.
But I have not provided the order. I am not aware of the just the from the sister. I have come to know that one appeal is pending.
I will give it on.
When is this order expiring? 6 weeks.
6 weeks. It's of 8 July 2020.
You still have time. Keep it on Tuesday. Give a copy and everything to her. We'll pass an order in this. Not today. Keep it on Tuesday.
My lord, that Advani is also required to go.
Yes, I'll pass an order. And you please provide.
The date was fixed, they were present, but I was informed that appeal is pending and
That is the reason why the inspection could not be conducted.
they were present with system.
Tuesday, we'll pass an order, Mr.
In the
Japan.
meanwhile, I'll give the papers.
Yes.
I'll give you.
All right, the rest of the matters, both the parties together, then we'll have it
Sir,
on.
item number 29, sir, item number 29,
Monday. Oh, you still around?
thank you. Yes, sir. Yes, sir. Sir, they have not filed any response.